Thank you to both of you. There's a lot to cover, and you've done a really great job of bringing us across a whole lot of this. The first thing I was going to ask is just actually a slight homework piece. Professor Forces, I saw that you had drafted some flow charts about decision making, and I was wondering if you would be able to provide copies of that to the clerk for the committee to be able to use.
Sure, absolutely. Although I fear the translator may be driven mad by the effort to turn my microprint into French and a 8x14.
No, that's great. Thank you. First, this is quite lengthy in legislation that we've been discussing, and one of the questions that comes to me when I speak to people in my community, and we do have a private member's bill in the House that's proposing it right now, is just repeal C-51 and leave us where we were pre-C-51. So just on that broad question, if I can ask first, and I can either one of you, why not just repeal C-51 and leave it where we were?
I guess my response would be that, certainly from my perspective, Kent Roach and I did not dispute the policy objectives that C-51 was trying to accomplish, with one exception, that is the new speech crime. We thought it was unnecessary. And so if one were to repeal those provisions that C-51 introduced, one would be left still with the policy issues that would have to be addressed. And so I see C-59 is dealing with those same policy issues, but putting each of the powers on a more sustainable footing. I would agree with what my colleague, Professor Carvin, said earlier, that not only is this just a question of constitutional niceties, it's also a question of certainty, and that many of the powers that were introduced by C-51 were clothed with such vagueness that the services might be disinclined to try to test them for fear that they would run afoul of a court or a commission of inquiry subsequently. So again, policy objectives were real. The drafting, in my view, was insufficient.
Just briefly, I would say something I think very similar, but expressed slightly differently, which is that, in my view, C-51 had good elements and bad elements. And I think that was also the Liberal Party's position, frankly, when it was the third party in opposition, that there were some elements they could support and some elements that they were committed to overturning if they ever came into office. And C-59 represents some effort to fix the so-called problematic elements of C-51, but it also provides space to add what I think are important new dimensions that were not addressed in C-51. So I would think it would be a time-wasting exercise, frankly, to go back and just reveal, simply eliminate all of C-51 from the law books. Better the approach that's been taken here.
Thank you. Professor Forces, when you were talking about data sets, I had a couple of questions. First of all, do you find that the definitions for data sets in Part 4, are they sufficient?
Data sets are not robustly defined, and so the definition of data set is fairly open-ended. It's an electronic record characterized by a common subject matter without further resolution as to what that means. And so left with a vague definition, I turn instantly to what checks would exist to rein in an egregious, overbroad understanding of what a data set might be. As compared, say, to the Security of Canada Information Sharing Act, where I agree with what was said before, that concept is overbroad as well. Here, this overbreadth is controlled by in-advance authorizations by independent individuals. The Intelligence Commissioner in relation to classes, authorizing classes for purposes of initial acquisition, scrutiny then by a limited designated employee for purposes of then approving, at least for Canadian data sets, retention of that data set by a federal court judge who is entitled to superimpose requirements on how it can subsequently be queried and exploited. And so it's a dynamic, the definition is broad, but there's a dynamic means of limiting its scope so that there are individuals independent of government who can look over the shoulder of the service and make sure it's not run amok.
Professor Rook, did you have something on
Sure,
that?
just very briefly. I mean, I would say, just in a slightly broader context, that the world of intelligence collection and national security protections that we live in now is one that absolutely requires intelligence agencies around the world to engage in the collection of data sets. And I think it's better to have this presented to the public in legislation as an acknowledged fact of life in the intelligence world. The challenge is, how to control the use of data sets, which mostly consist of metadata. And from my perspective, the legislation does not a bad job in that regard. The biggest question I have about it is the legislation would like to draw distinctions between foreign data sets and Canadian data sets and surround each of them with different legal protections. And I understand that in theory. In practice, and I've raised this with CSIS and CSE officials, in practice I'm not sure how that's going to be done, because we're talking about a much more blended pool of information. And so I would encourage, I think, the committee to hear some more precise testimony from officials involved in thinking through the data set problem as to whether you can really distinguish between these two things, because if you can't, the legal surround that we're trying to provide for it doesn't make a whole lot of sense.
All right, thanks. I only have a minute and a half, so I wanted to jump to retention issues. You had raised with data sets concerns about retention issues. Can you please outline those briefly?
So my single concern really relates to the circumstances in which the director of CSIS can authorize a query of a data set that hasn't gone through the regular retention process that involves the federal court, for instance. There's no indication in the statute as to what the service can then do with the product of that query. For regular queries, there are rules about retention and what circumstance can it be retained. For exigent queries, those rules are not there, and so I'm not sure whether this is a glitch in the drafting or whether this is intended. So it seems to me it would be very easy to pull the results of those queries into the regular retention regime, but at present I don't see how it does so.
Do you have any suggestion with 30 seconds as to how we would word that if we were trying to...
Off the top of my head, I would just make it clear that the results of queries done in exigent circumstances under 11.22 should be tied into the rules on retention that you find in 11.21. I'd have to, obviously that's going to require some tinkering.
Yeah, that helps. Thank you.
Thank you, Ms. de Bruijn. Monsieur Paulus.